Can you imagine losing your tech job, following the law by staying within 60 days grace period and suddenly receiving a formal notice to appear in immigration court? Well, that is a nightmare thousands of H-1B workers they are facing right now. Notices to appear, or NTA, they are being issued to laid off workers, basically triggering immediate deportation risk. Now, we are breaking down why this administrative mess it is happening and the critical steps that you should take to defend your legal status. Under Federal Regulation 8 CFR and 214 I2, terminated non-immigrant workers they are granted up to 60-day grace period to find a new employer, file an H-1B transfer or change status to a visitor or a spouse visa. So, where are NTAs turning up in mailbox during that particular window? Well, it comes down to three main factors. First, when a company lays off a worker, federal law requires them to notify USCIS to withdraw the H-1B petition. Here, in many cases, USCIS processing system automatically flags the worker as out of status upon receiving the withdrawal, completely ignoring the worker's active 60-day grace period. Then many workers file a form I-539, change of status to B2 visitor or H-4 dependent, and that too during their grace period. A timely filed application grants an unauthorized period of stay. Yet, NTAs are still being triggered before the application is even opened. And third, the 60-day rule, it is technically discretionary for DHS, while aggressive automated routing treats workers as removable from the exact day of termination. Receiving an NTA, it is not just a warning letter. It officially places you in an administrative removal proceeding before an executive officer for immigration review judge. Now here's the big trap. Do not immediately pack your bag and leave the country. If you receive an NTA without consulting a qualified immigration attorney, if you depart the US while an active NTA is on file without the court formally terminating your proceeding, then sadly, but you could be hit with an in absentee order of removal, triggering multi-year or maybe 10-year re-entry ban in the US. Well, if you or somebody you know receives an NTA while within your 60-day grace period or while a change of status is pending, here is the legal defense strategy for you. First of all, file a monitor to dismiss or terminate. An immigration attorney can file a motion to terminate with the immigration court, submitting proof that you were within your valid 60-day window or had a timely filed petition pending with the NTA was generated. Second, secure an H-1B transfer or COS. If a new employer files an H-1B transfer, Form I-129 via premium processing and USCIS approves it. Your attorney can present the approval notice to the immigration judge just to dismiss the removal proceeding further. And yes, document every single day. Maintain the clear proof of your termination date, your last paycheck, or your severance notice to prove that your 60-day clock that started accurately. Navigating a job loss on an H-1B that is stressful enough without system glitches threatening your immigration status. Always work with a legitimate immigration lawyer if you receive an official court notice. Share this video because it will help many H-1B workers to save from a lot of mess.